Delivery of judgment, item 23.
Judgment, both the judgment and deferred till tomorrow. Tomorrow I'll be delivering.
Obliged.
May it please your lordship. Lordship, regarding item number 12 and 13, lordship, I may be allowed to mention the matter when the matter reaches lordship.
Okay. Then why are you mentioning now?
No, lordship, actually, like, I tried to contact the other side, they told.
Wait till the matter is called.
Lordship, I obliged.
May I please, Lordship. Item number 18, Lordship. Yesterday, I filed an affidavit, Lordship. I am for the respondent, Lordship. That may take with the record, Lordship, today itself.
If it,
All for it.
yes.
My lord, I beg to mention item number 27, my lord. So,
I'm a respondent. My lord,
No.
I am respondent in this case and I have mentioned it for arguing the case, but she needs time, my lord,
at, my lord, on 6th of.
6th of, yeah,
Friday.
March.
6th of March, my lord.
Heard Miss S.B. Chaudhary, learned counsel for the appellant. Also heard Miss K. Devi, learned counsel for the respondent. Learned counsel for the appellant prays for an adjournment on the ground of personal difficulty, to which learned counsel for the respondent does not raise any objection. Hence, the prayer is allowed. Let this matter be listed on 6th of March.
Yes. Hello, bless.
May I please, Lordship. Lordship, I'm praying for listing of a first appeal from orders, Lordship. That is in the hearing stage, Lordship. What happened here in this case, Lordship? For the last 3 years, this case is not listed, Lordship.
5th of March.
5th of March, Lordship.
May I please, your lordship. I pray for listing MSc appeal, your lordship. Orders, no.
5th of March.
I'm sorry.
Lordship, I'm praying for listing of a testamentary appeal in the orders column, Lordship.
6th of March.
May it please your lordship, I beg to mention listing of 2 MFAs in the first week of April.
For what?
Railway claims, lordship,
For,
for order.
okay. Okay.
Much okay.
For reference to a special mediation, item number 1.
May I please, your lordship. What LCR is already received.
This is already in hearing stage, lordship. So lordship may fix the date after 10th of March, if possible.
No, whether it can be referred to
No,
mediation.
lordship.
Why?
Because third party factor is there, that is one of the ground that we have taken.
My lord, this is genuine case, my lord. The applicant's husband died due of accident, and during trial, my lord,
Heard,
the insurance did not adduce any evidence in support of their claim. And the trial court rightly passed the judgment.
okay, heard Mr. S.P. Sharma, learned counsel for the appellant. Also heard Mr. K. Kolita, learned counsel for respondent number 1.
1 to 4.
1 to 4. Though this matter has been listed today to ascertain whether there is a possibility of any amicable settlement between the parties so that matter may be referred to mediation under the special drive mediation for nation, however, learned counsel for the both parties have submitted that this matter is not a fit matter to be referred to mediation. They also submit that the matter is ready for hearing and it would require an adjudication by court after full hearing of the case. Considering the submissions made by learned counsel, this matter is not referred to hearing. List this matter for hearing on 5th of May.
But cannot be possible to fix in the March month.
March.
The applicants are
12 from 12.
26 May.
Twen-
Not you.
26th March.
Obliged.
obliged.
Item 2.
May I please your lordship? You are filing an IA to bring on record the correct address of the respondent. Para 5 contains the correct address.
Where is the I?
IA 454 of 26.
Not Mr. What is your name?
D. Mazumdar, Lordship.
D. Mujumdar, learned counsel for the applicant. This interlocutory application has been filed by the applicant / appellant in connection with connected FAO number 71/2025. In this interlocutory application, the applicant has prayed for allowing the applicant to state correct address of the respondent in the memo of appeal as indicated in paragraph number 5 of the instant interlocutory application. The prayer is allowed. The applicant is allowed to rectify the address of the, how many respondents are
The
there?
sole respondent, Lordship.
Address of the sole respondent in the connected appeal by filing an amended memo of appeal. This interlocutory application is accordingly disposed of. In appeal, in view of the order dated 24/2/2025 passed in IA number 454/2026, let this matter be listed after a week so as to enable the appellant to file a rectified memo of appeal in terms of the orders passed in the aforesaid IA. List accordingly.
Much obliged.
Orders, item 3.
Lordship, this matter is wrongly listed in the orders column. It should be, it was last listed for hearing.
It is
I am
ready.
appearing for 4 and 5.
It is ready for hearing.
Also
Yes,
have been
sir.
listed on hearing column. As per last order, 7/1/24.
7/2/24.
Heard Ms. K. Bhattacharya, learned counsel for the appellant. Also heard Mr.
M. Pathak.
M. Pathak, learned counsel for
4
respondent
and 5.
number 4 and 5. It is submitted at bar that this appeal has been wrongly listed in orders column. It ought to have been listed in the hearing column in as reflected in order dated 7/2/2024. Stop. List this appeal for hearing on 23rd April.
Yes, sir. 23rd. May I please, Your Lordship. My lord, may I peruse the last order. 16/2.
What is this I for?
I have for condemnation of delay of 147 days in preferring the RFML. We have explained in paragraph 3 and 4, madam. Basically in 3.
Heard Mr.
SK Chakravarti.
S.K. Chakravarti, learned counsel for the applicant. This application was directed to be proceeded ex parte against the respondents by order dated 16/2/2026. Stop. Today also, none has appeared for the respondent. Stop. This application This interlocutory application has been filed by the applicants for applicant praying for condonation of delay of 147 days in preferring the. You have committed blunders in your drafting.
Matlab the handwritten one, matlab.
No. You, I have underlined it.
Oh.
You go through. Look at the cause title page.
First page, my lord.
Later on, you go through it. क्या लिखा? In preferring the connected regular first appeal. This is appeal against
Matlab judgment and decree dated 12/7/2022 passed in title suit number 72 of 2016.
whereby the applicant has impugned the judgment and decree dated
12/7/2022.
12/7/2022 passed in title suit number 72/2016 by the Court of Learned Civil Judge Dibrugarh. Why is the delay?
Delay, my lord, actually he met with an accident. As a result, my lord, he suffered serious grievous injuries in his spinal cord, and because of which he became physically
Learned
incapacitated.
counsel for the applicant has submitted that the applicant could not prefer the connected appeal within the prescribed period of limitation, as he had suffered, he met with an accident wherein he suffered serious injuries on his person, which restricted his movement. He further submits that the applicant has fully explained the cause of delay in paragraph number 3 of the instant interlocutory application. Stop. I have gone through the statement made in the instant interlocutory application. Stop. After going through the reasons shown by the applicant in paragraph number 3 of the instant interlocutory application, it appears that the applicant has shown sufficient cause which had prevented him in approaching the court for filing the connected appeal within the prescribed period of limitation. Accordingly, this interlocutory application is allowed, and the delay of 147 days in preferring the connected appeal is hereby condoned. The registry is directed to register the connected appeal and list the same for admission after a week on a date to be fixed by it. This interlocutory application is accordingly disposed of.
I apologize for the mistake, madam. They ought to have been first appeal, or in the writ appeal as well.
Item 5.
In this case, the service on reson number 4 is a necessary party, it's not complete.
As per number 1, 2, 3 and 5, 6, I am representing.
Heard Mr. R. Goswami, learned counsel for the appellant, Also heard Mr.
S.C.
S.C. Pandit, learned counsel for respondent number 1, 2, 3, 5 and 6. On perusal of the office note, it appears that the notice issued to respondent number 4 has not yet been returned. Stop. The registry is directed to place the postal track consignment report of the notice issued to respondent number 4 by speed post. By speed post on the next date fixed. Let this matter be lost.
Lordship, interim completion maybe.
Let the service be complete.
Let the service be complete on 6th of March. 6th of March.
Item 6.
Please, your lordship. Also, this case is actually ready for hearing. LCR has also been received. But my learned friends is insisting for 50% hearing of the stay petition.
No, we will hear it finally.
No, lordship, actually, this.
If it is ready for hearing, we will fix it.
No, lordship, scan copy of LCR has come, lordship. And the proceeding is there, Bakija proceeding is pending there also. Lordship. So, lordship, I have been pricked into it because I have been pressing for and.
Bakijay proceeding is pending.
Yes, lordship.
You proceed with Bakijay.
No, lordship, the thing is this, it is fixed for hearing, there 50% is death case, lordship. It is already late, too much late.
No, we will complete the hearing. We'll give a short date.
Not that is why.
And in the meanwhile, there is no bar in proceeding before Bakijay. You take 100%, it is.
No, lordship, since stay petition is filed, lordship. So I humbly supplied, lordship, that 50% if allowed, then.
Date 19th March. We'll hear the.
Lordship, within that, before that time, he should not proceed with execution because I have been pressing for disposal, he has been pressing for stay.
Then you pay 50%. If you.
Can it be heard earlier than that, lordship? My point is that lordship, before he 50% today itself is granted, I will receive the indemnity bond. He ought not to have proceeded his
No,
petition.
if I direct them to pay 50%, they will take 6 weeks time to
No,
deposit.
lordship, 4 weeks.
And within 4 weeks, we are fixing hearing before that 4 weeks
I
time.
humbly submit that, lordship, 50% may kindly be allowed, let them pay it at any time, lordship. So that I should not proceed with the Bakija.
No, you proceed in Bakijay matter. Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. A. R. Agarwala, learned counsel for the respondent. Since this matter is ready for hearing, list this appeal for hearing on 19th of March.
Look, if I humbly submit to that 50%, stay petition. Subject to production indemnity bond. Yes, lord. I don't know why, it can be disposed of in 4 weeks. Let's see.
Where is the.
Stay there, lord. I'll give the indemnity bond, lord.
You will pay before 19th.
No, lord.
Can you pay?
Well, it normally takes time, about 4 weeks time is necessary. 4 weeks time.
Then we'll take up the IA on 19th. List this.
If the date is given little bit later.
No, list this matter along with the connected FO in 19th.
Since it is come in the orders column, lord, see, hearing column, that will be different, lord. So that may can be extended little bit.
No. Come ready, prepared for hearing on 19th.
Lord, before 19th, if they will pay, lord, then. That may
There,
can be.
it is not possible.
There will almost 4 weeks, 100% on 19th, lord.
Next time. You go for 100% on 19th instead of 50%. Press for taking the matter as first item on 19th.
Lord, I humbly request, lord, only paid because this is one person died, Lordship.
Therefore, I am saying that give effort to finally dispose of the matter. If you are entitled to
My
100,
learned penny is saying that before 19th, if they will pay or before whatever, in the time we'll hear the matter on the 19th, Lordship.
prayer is rejected.
Item 7. Much better.
May please lordships. In this case, I am for the respondent number 1, my lord, the claimant, my lord, victim.
Why it has come up for
Already, my lord, the.
Lordship, what happened, this case was, set for
referred to
local last
local
occasion. Because of non-appearance of the parties, it couldn't be settled, Lordship. But this time it
Yes.
can be settled, Lordship. It may be sent
My
for.
lord, they are not, my lord, agreed, my lord. Claimant is not agreed. my lord.
We'll
Because
adjust that amount.
he was undergoing a medical, my lord, at Hyatt Hospital.
We'll enhance some amount
Lord.
this time, Lordship.
Is there any possibility? Last time you appeared,
No, no.
My lord,
Okay.
not my lord. Well,
whether you will appear before Lok Adalat this time.
But they have agreed to the amount. They have submitted the agreed amount to the company.
my
Okay.
lord.
And
Verbally, my lord.
the appellant is also ready.
I'm ready. We are ready. We are also ready to enhance some amount also. Because if they are saying that they need some enhancement.
Not Mr. P.J. Burman, learned counsel for this is item number,
7, Lordship.
learned counsel for the appellant. Also had Mr. T. Uddin, learned counsel for respondent.
I'm S. Ahmed, my lord.
Sorry.
On behalf of T. Uddin.
Learned S. Ahmed, learned counsel for respondent / claimant. It is submitted by learned counsel for the appellant that though this matter was listed before Lok Adalat on 13th of December 2025, however, due to non-appearance of parties, the matter could not be settled. He submits that in the meanwhile, the parties have arrived at, no, in the meanwhile, there is some development and there is a possibility of amicable settlement between the parties in the ensuing Lok Adalat. And therefore, he prays for listing this matter on 13th of March 2026 before the Lok Adalat. Learned counsel for respondent / claimant, 14th of March.
14th
of March.
14 hours.
Does not oppose the prayer, hence the prayer is allowed. Let this matter be listed again before the ensuing Lok Adalat on 14th of March 2026.
My lord, my name may be shown, my lord. On next
Name of Mr. S. Ahmed may be reflected in the cause list as engaged counsel for the respondent / claimant.
obligement.
Item 8.
Much obliged.
I am appealing for the respondent number 3, my lord. I will file objection against the delay petition, my lord.
100 days delay, your lordship. I have explained in paragraph 4, 5, and 6.
Third, Mr. What is your name?
Be my lordship.
B. Kumar, learned counsel for the applicant. Also, Ms. S. Roy, learned counsel for respondent number 3, who submits that she may be granted some time to file a written objection against the prayer made by the applicant for condonation of delay. Stop. The prayer is allowed. Let this matter be listed when
4 weeks, my lord.
Date may be fixed, your lordship.
23rd March.
Obliged.
Item 9.
May I please, your lordship, according to office note dated.
Respondent claimant.
How many respondents are there?
2 respondents.
You are appearing for
Respondent number 1,
1
Mangalam.
and on 2.
Respondent number 1.
Respondent 2 not.
You are appearing for only 1.
Yes.
Heard Miss P. Sutia, learned counsel for
For
the
both.
learned counsel for the applicant. Also heard Mr. What is your name?
J. Kalita.
J.
Aman Ali on behalf of J. Kalita.
Mr. Ahmed Ali appearing on behalf of
Aman Ali.
Mr.
Aman, A-M-A-N.
Aman
Ali.
Ali appearing on behalf of Mr. J. Kalita, learned counsel for respondent number 1 and 2. What is this?
My lord.
This
There is a, we don't have any objection if delay is funded.
this
There is a delay of
application
40
under Section 5 of the Limitation Act has been preferred by the applicant / appellant, praying for condoning the delay of 46 days in preferring the
47 days, my lord.
47 days in preferring the connected appeal against judgment and order dated 18/7/2025 passed by the learned Commissioner, Employees Compensation Borpeta in EC case number 44/2024. Stop. Learned counsel for the applicant has submitted that the applicant has explained the reasons for delay in approaching the court in filing the connected appeal. In which paragraph here? In paragraph number 4 and 5 of the instant interlocutory application. Learned counsel for the respondent submits that considering the reasons shown by the applicant in the interlocutory application, he does not have any objection regarding condonation of the delay of 47 days. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the records. Considering the reasons shown by the applicant in paragraph number 4, 5, and 6 of the instant application to be sufficient cause which prevented the applicant in preferring the connected appeal within the prescribed period of limitation, as well as considering the fact that the respondent has not opposed to the prayer for condonation of the delay, the delay of 47 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. Registry is directed to register the connected first appeal and list the same for admission after a week on a date to be fixed by.
My lord, there is a mistake, my lord. I am for respondent number 1. For respondent number.
What you were doing while I was dictating the order?
I took behalf for court, my lord. Please now. Yes.
Who is respondent number 2?
I don't know.
Atwar Ali, owner of the vehicle. Lordship.
What should I do to you?
Lordship.
Kato. It appears, Mr. What is your name?
Aman Ali.
Be louder.
Aman Ali.
Aman Ali
On behalf of Jekali.
appears on, he submits that he appears for respondent number 1 only. Stop. On perusal of the office note, it appears that the service report in respect of the notice issued to respondent number 2 has not returned. The registry is directed to place the postal track consignment report of the notice issued to respondent number 2 before this court on the next date fixed. List this matter on 6th of March.
Item 25 from supplementary list.
May I please, your lordship?
Lordship, as per office note dated 23/2/26, service upon the respondent has returned unserved.
Return without service. What should be done?
Fresh steps may be done.
You are husband or wife?
Wife petitioner, Mamtaz Begum.
Oh. Heard, miss. What is her name?
ZR Majumdar appearing on behalf of Dr. P. Agarwal.
S. Majumdar.
ZR.
Heard, Miss Jed R. Mazumdar appearing on behalf of Dr. P. Agarwal, the learned legal aid counsel for the petitioner. On perusal of the office note, it appears that the notice issued to the respondent by way of speed post has returned with an endorsement within inverted comma, no such person in the address. Stop. In view of the aforesaid office note, the now further continue. Further, it also appears that notice issued to the sole respondent by usual mode has not yet returned. Await for the receipt of service report of the notice sent to the respondent by usual mode. In the meanwhile, the petitioner shall also make some endeavor to find out correct address of the respondent. List this matter on earlier 6th of March. 6th of March.
Lordship, can it be on 9th of March?
9th of March.
Yeah.
Item 26. Item number 26.
None has appeared for the applicant on call. Let this matter be listed again on 2nd of March.
Here, item 10.
Yes, Your Honor. My senior leaks in some other court, so matter may be passed over for time being.
Lordship, we will wait for this case because this matter is squarely covered with the judgment of this honorable court, Lordship.
Okay, we'll take it up after some time.
Obliged.
Item 11.
May it please your lordship. Your lordship, the owner has preferred this MSc appeal. And the respondent number 2, they are the insurance company. They have been struck off because the offending vehicle was not having a valid policy. Now, your lordship, the case in brief is that the owner was driving a scooter and he dashed into another vehicle. And that vehicle was a motorcycle and it was driven by the claimant. which is the respondent number 1 in this matter. Your Lordship, after the accident, the respondent number 1, which is the claimant, has suffered some injuries, and after that, he has claimed for damages before the tribunal, and after that, award was passed, and we are challenging that award. Now, our grounds of challenge are in page number 3, Your Lordship.
Just a minute.
First ground
Yeah,
is
just a minute, just. Yes.
Your Lordship, the first ground is that the learned member did not consider the evidence of the DW1 and DW2. It is in page number 11 of the memo of appeal. Paragraph number 9 in page number 11, Your Lordship. May I read the paragraph?
What he has not considered.
In Your Lordship, paragraph number 9, may I read, Your Lordship?
No, before you read, you tell me what has not been considered.
Your Lordship, they have stated that the DW1 and DW2 has stated that the negligence was the claimant's, solely the claimant's negligence, due to which the accident occurred. So,
Okay, read. Page number?
page number 11, Your Lordship.
Yes.
Paragraph number 9, Your Lordship. The last paragraph.
You're reading from judgment?
Yes, Your Lordship.
Okay.
May I read, Your Lordship?
Yes.
To rebut the evidence adduced by the PWs on the point of negligence, OP number 2 examining himself as DW1 and one alleged eyewitness as DW2. DW1 in his evidence deposed that on 29/7/2006 at about 8 p.m. while he was proceeding towards his house from Ganeshguri at Ganeshguri near Ganesh Mandir, accident took place due to careless and negligent driving of the motorcycle bearing number AS so and so. He further deposed that in the GR case registered against the OP number 1 and 2 got acquittal from the charges leveled against him. DW2 Sri Dhoniram Kalita claiming himself to be eyewitness. Your Lordship, page number 12 has supported the version of DW1. Both of them denied the claimant's suggestion that they deposed falsely. PW2 in his evidence admitted the fact of facing criminal trial for negligence. Acquittal from charge of rash driving in criminal trial cannot be treated that the driver of not negligent because standard of proof in criminal trial is of beyond reasonable doubt, whereas the standard of proof in holding negligent for accident is on the touchstone of preponderance of probability. On careful comparison of the evidence on record, it is apparent that the evidence of claimant's side is found more trustworthy and reliable that of the DW1 and DW2 on this point. So, Your Lordship, the learned member completely disregarded the statement of the DW1 and DW2. That is one ground, Your Lordship. The second ground. Your Lordship, the second ground is that the learned member wrongly accepted the income of the claimant at rupees 10,000 per month without there being any evidence in the record. Now, Your Lordship, I will take Your Lordship's attention to page number 9. The first paragraph, Your Lordship.
Yes.
Your Lordship, there I will read from the second line, Your Lordship. At the time of the accident, he was 26 years old and was doing private service, having his monthly income of rupees 10,000. That much, Your Lordship, regarding this ground.
No, how the tribunal was wrong?
Because there was nothing to indicate that he was earning that much, 10,000 rupees in this
Okay.
case. And he was a service holder. Now, Your Lordship, coming to the third ground. Your Lordship, the injured claimant was admitted in the GMC hospital on 29/7/2006 and thereafter discharged on 31/7/2006. Again, for better treatment, he was shifted to GNRC hospital on 31/7/2006 and discharged on 16/8/2006. So, Your Lordship, he was only admitted for 17 days. But here, Your Lordship, the tribunal has considered that there was a loss of income of 5 months. And therefore, 50,000 was awarded in that regard, in regard to loss of income. So that is also we are challenging. Now, regarding this point, Lordship, come to page number 12. Para number 12, page number 12, Your Lordship. May I read, Your Lordship?
Yes.
Now coming to the quantum of the compensation to which the claimant is entitled, the claimant Bhupen Hazarika in his evidence deposed that due to the accident he sustained head injury. Initially, he was treated at GMCH and admitted at JNRC hospital as an indoor patient and was treated there for about 17 days. On going through the exhibit 3, 3 in bracket 4, discharge certificate issued by JNRC hospital, it appears that the claimant Bhupen Hazarika was treated there as an indoor patient from 31/7/2006 till 16/8/2006. Exhibit 3 in bracket 4 also shows that he was diagnosed injury to head in an RTA on 29/7/2006. PW4 has confirmed the fact of getting head injury by the injured and taking treatment at JNRC as indoor patient for about 17 days. PW1 has proved several vouchers for purchasing medicines during his treatment by Exhibit 5 series. No serious objection has been raised by the contesting opposite parties. From the 5 series vouchers, it appears that the claimant has spent rupees 1,01,571 on his treatment, which he is entitled as pecuniary damages. So, Your Lordship, only for 17 days he was admitted, and loss of income was assessed for 5 months, and it came out to be 50,000. So we are challenging that part. That is the last ground, Your Lordship. That's all.
Yes.
Please, Your Lordship.
My lord, it is not a case that the tribunal did not consider, my lord, the evidence of the DW 1 and 2. My learned friend did not read para 8, my lord. If your lordship comes to para 8, we have to read the entire judgment. And I'll also show, my lord, the evidence of DW1 and DW2 are not consistent. I'll come to the evidence, my lord. Now, if you read para 8, my lord, So far negligence aspect in the accident is concerned, the evidence of the claimant, so far accident due to rash driving of the OP number 2 remained unshaken in cross-examination by OP side. To prove the fact of negligence of the OP2, claimant has examined one eyewitness of the occurrence as PW3, who in his evidence has fully supported the evidence of PW1. In his evidence, PW3 categorically deposed that the accident occurred due to rash driving of the scooter driver OP2, who knocked the motorcycle driven by the claimant on his side of road. PW5, the IO, who has conducted the preliminary examination, has also deposed that during his investigation, it came to light that accident occurred due to negligence of scooter driver. So here, my lord, the tribunal has relied on the evidence of the claimant, PW1, PW3. Now your lordship will see, my learned friend has already read para 9. I take your lordships to last part of the para 9, page 12. On careful comparison of the evidence on record, it is apparent that the evidence of claimant side is found more trustworthy and reliable.
Why?
Yes, my lord, and reliable than of DW1 and DW2 on this point. Now, if I take your lordships to the evidence of DW1 and DW2, your lordship will find that they are not consistent. My lord, the records are there, my lord. I have got the evidence of DW1 and DW2.
Yes.
Now, the evidence of DW1, Horidhan Talukdar, the relevant part, my lord, page para 6. May I read it, ma'am?
Yes.
That the fateful day, i.e. 29/7/2006, at about 8 p.m., I was going to my house at Kahilipara from Ganeshguri. Suddenly, when I reached Ganeshguri, the accident took place due to fault of the claimant's husband, as the claimant's husband was driving his motorcycle, white number so-and-so, carelessly and negligently, and as a result to save himself. The OP1 and 2 took the side in the backside of the tracker, but he could not save himself, and beyond control, the claimant's husband himself hit the opposite party's vehicle and got injured himself. I was driving my vehicle behind the tracker, which was also running from Rajdhani Masjid, Ganeshguri side to Kahilipara. My lord, this is his version. This tracker and all has come in. Now, if your lordship, my lord, compares this part of the evidence with DW2, which the tribunal says that it finds the evidence of PW, my lord, more reliable. This is the reason, because the story, my lord, does not tally with each other. It's not consistent. DW2, Dhoniram Kolita. What he says, my lord, he projects himself as the eyewitness. Your lordship has got it, my lord. DW2, Dhoniram Kolita.
Yes.
I may read it, my lord.
Yes.
I was the eyewitness. The accident taken place in the evening about 8 p.m. on 29/7/2006 at Ganeshguri near Ganesh Mandir. At that time, I was waiting for bus. The opposite Horidhan Talukdar was coming from his office towards Rajdhani Masjid to Kahilipara in his scooter, white number so-and-so. When Horidhan Talukdar reached Ganesh Mandir, the husband of the claimant drive the motorcycle rash and negligently in the wrong side and hit the motorcycle of the opposite party. due to the accident occurred by the husband of the claimant of the opposite party, or written talukdar was injured. So Lordship will kindly see, my lord. These are two different versions. If he was, my lord, the eyewitness, then he would have, my lord, his version would have would have been inconsistent with DW1. And therefore, my lord, the tribunal found, in my respectful submission, that, my lord, the evidence of PW1 is more reliable, more trustworthy.
What is the discrepancy?
Discrepancy, my lord, the narration of PW1, that some tracker, he was behind the, my lord, backside of the tracker, and thereafter he saved, my lord, he lost control, and thereafter the accident took place. This, my lord, the part of the story is missing, my lord, in DW2. If I read again, my lord, DW1, the OP1 and 2 took the side of the backside of the tracker, but he could not save himself, and beyond control, the claimant's husband himself hit the opposite party's vehicle and got injured himself. So tracker, my lord, in between has come in, and this part is missing, my lord, in DW2. If I say, my lord, that the version is totally inconsistent with each other, and therefore the tribunal has rightly, my lord, rejected the evidence of DW1 and 2. And it is not a case that the evidence of DW1 and 2 were overlooked by the tribunal. It was appreciated, and rightly, my lord, this was rejected.
Okay.
Now, my lord, so far as the second ground is concerned, regarding, my lord, income certificate, my lord, my learned friend has also not drawn your lordship's attention to the Exhibit 6, which is recorded by the tribunal itself, page 10 of the appeal, para 7. If your lordship comes to para 7, issues 1 and 2, there are exhibits mentioned, my lord, and the second line from the bottom, income certificate as Exhibit 6, A to B. There was an income certificate. And if I take your lordships, my lord, to the evidence of,
Which para you are referring?
my lord, I am referring to para 7, second line from the bottom. There are other exhibits mentioned, including income certificate as Exhibit 6. My learned friend has, my lord, submitted that out of the blue, the tribunal has recorded that his monthly income is 10,000 without any supporting documents, man. This is not correct, because Exhibit C is the supporting document, man.
Exhibit
6. Income certificate as Exhibit 6. Para 7, second line from the bottom, my lord. There is Exhibit 6, my lord, in on records.
Yes.
Now, my lord, ground number 2 and ground number 3, both, my lord, would be covered by the evidence of, my lord, PW6. My lord, appellant, my lord, is of the contention that there was no material with regard to, my lord, the income. And second, my lord, argument is that Joe, my lord, he was admitted for only 17 days, but the loss of income is calculated, my lord, to be of 6 months without any basis, my lord, or 5 months without any basis. That your lordship will find the supporting, my lord, evidence of PW6, my lord, who is one Bedo Kinkor Goswami, my lord.
Who is he?
My lord, he was the employer, my lord. He was an employee of, my lord, the Ghosh Brother Automobiles, where, my lord, the claimant was also working, my lord. If your lordship permits, my lord, I may read PW6.
Yes.
Sri Bedo Kumar Goswami as PW6, my lord. He was the finance manager, my lord, who had issued the Exhibit 6.
Yes.
that on 11/12/2006, I was doing work as finance manager, accounts officer, and authorized signatory in the Ghosbada Automobiles, a certified company, passenger car dealer, so and so. That I know Sri Bhupen Hazarika. He was an employee and working as collection executive loan recovery section in the Ghosbada Automobiles since April 2006. He sustained grievous motor vehicle accident on 29/7/2006. He was absent from his duty with effect from 31/7/2006 to 31/12/2006. This 6 months, man. Due to major injury of road on 29/7/2006. During this period, he was granted leave as without pay basis. He was drawing a monthly salary of rupees 10,000 per month. He again joined service on 1/1/2007. And thereafter, my lord, Exhibit 6, my lord, was issued by him. This is, my lord, the income of, my lord, the claimant. Because he was the finance manager and authorized signatory, he could have issued that. So, my lord, my respect to submission is the order, judgment, and award of the tribunal does not suffer from any infirmity. It is not a case, my lord, that it is perverse. Without any document, without any evidence, my lord, the award has been, my lord, passed. And secondly, my lord, in MICT cases, your lordship is aware, my lord, it's only on the touchstone of preponderance of probability. There are sufficient materials, my lord, to show that the, my lord, claimant was negligent, and due to his negligent and rash negligence driving, my lord, the, my lord, injury had, my lord, taken place. So on these three grounds, my lord, which have been contended by the appellant, my lord, I have responded to it. I have responded. So therefore, there are no other grounds. On quantum, my lord, they have not challenged anything. That, my lord, it is unjustified.
Okay.
So my humble submission, my lord, with interest, my lord, he should pay only amount of 2 lakhs.
Anything?
Lordship, we have already deposited, I think they have withdrawn
How much?
75,000 we have already deposited. Your Lordship, only one prayer, the statutory amount may be refunded. Otherwise, that's
Heard Mr. S. Datta, learned counsel for the appellant. Also heard Mr. S. K. Talukdar, learned counsel for the respondents. Respondent number 1/claimant. Anyone appearing for respondent number 2? No.
No one, my lord.
This appeal under section 173 of the Motor Vehicle Act, 1988 has been preferred by the appellant Shri Haridhar Talukdar, impugning the judgment and award dated 24/10/2016 passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro, in MEC case number 1136/2006, whereby the present appellant was directed to pay a compensation amount of rupees 2 lakhs along with an interest at the rate of 6% per annum from the date of filing of the additional evidence on affidavit, that is 15/2/2014, till the payment of the same to the claimant. Stop. The facts relevant for the consideration of instant appeal, in brief, are that on 29/7/2006, the claimant Shri Bhupen Hazarika was proceeding towards Jotia proceeding from Jotia towards Ganeshguri in his motorcycle at about stop at about 8:15 p.m. near Ganesh Mandir, Dispur, a scooter bearing registration number AS25B1498 being driven in a rash and negligent manner hit his motorcycle, and as a result of which he sustained injuries on his head, chest, face, and other parts of the bodies. He was immediately taken to Gauhati Medical College Hospital for treatment, and thereafter he was shifted to GNRC for better treatment. So thereafter, the respondent number 1/claimant approached the Motor Accident Claims Tribunal number 3, Kamrup Metro at Gauhati, by filing a claim application seeking compensation for the injuries sustained by him in the vehicular accident. The opposite parties, including the insurance company of the scooter as well as the present appellant, contested the claim of the respondent number 1 by filing written statement. And filing written statement stops. On the basis of the pleadings of the parties, the Motor Accident Claims Tribunal framed following issues. Court issues from, just a minute. Issues from page number 9 and 10 of the judgment, marked as A. Here plus I logo. Stop, next para. During the inquiry, in support of the claim petition, the claimant Shri Bhupen Hazarika examined himself as PW1 and 5 other witnesses, and also exhibited several documents. The opposite party number 1 and 2 had examined 3 witnesses. Three witnesses as DW1, and 2 witnesses as DW1 and DW2. The evidence on affidavit submitted by opposite party number 3 within bracket insurance company was expunged as the said witness did not turn up to face the cross-examination stop. Ultimately, by the impugned judgment and award, the Motor Accident Claims Tribunal held the present appellant liable to pay the compensation amount to the respondent slash claimant in the manner as described in the foregoing paragraphs. Stop. It was held by the tribunal that the policy in question in respect of the offending scooter was not valid at the time of accident, and therefore the insurance company was not liable to indemnify the owner, and the owner within bracket the appellant. Accordingly, the appellant was held liable to pay the compensation to the claimants. Stop. Though in the memo of appeal, the present appellant has taken several grounds for impugning the judgment and award passed by the Motor Accident Claims Tribunal. However, during hearing, the learned counsel for the appellant has mainly pressed for 3 grounds, as discussed herein below. Stop. Mr. S. Datta, learned counsel for the appellant, has submitted that the Motor Accident Claims Tribunal had erred in attributing the negligence to the present appellant, as a result of which the accident occurred, by ignoring the evidence adduced by DW1 and DW2. He submits that DW1 and DW2 have categorically stated in their deposition that the accident in question had occurred due to the negligence of the driver of the motorcycle, that is the claimant. However, said testimony was not taken into consideration by the Motor Accident Claims Tribunal. Hence, he submits that the Motor Accident Claims Tribunal had erred in arriving at the conclusion regarding the negligence due to which the accident occurred. Stop. He further submits that the next paragraph, he further submits that the Motor Accident Claims Tribunal has also erred in assessing the monthly income of the claimant at ₹10,000 without there being any evidence to that effect on record. He further submits that though the evidence on record suggests that the claimant was admitted in the hospital after the accident only for a period of 17 days. However, while assessing loss of income, the tribunal came to a conclusion that the claimant suffered loss on income for 5 months without there being any evidence to that effect on record. He therefore submits that the tribunal was wrong in directing the appellant to pay the compensation to the claimant. Stop. And hence he submits that the impugned judgment and award is liable to be set aside. Stop. On the other hand, Mr. S.K. Talukdar, next para. On the other hand, Mr. S.K. Talukdar, the learned counsel for respondent number 1 has submitted that the tribunal has correctly assessed the evidence on record and thereafter directed the appellant to pay a sum of rupees 2 lakhs. He submits that there is no infirmity in the impugned judgment and award passed by the tribunal, and therefore tribunal stop. He submits that the testimony of the present appellant as PW1 before the tribunal regarding the negligence of the appellant in driving the scooter in rash and negligent manner which caused the accident has been corroborated by the testimony of other eyewitnesses, namely PW2 and PW3. He submits that the PW3, who is an independent eyewitness, has categorically deposed that the accident had occurred due to rash and negligent driving of the scooter driver, within bracket the present appellant. A scooter driver is the present appellant. Present appellant, who had knocked the motorcycle driven by the claimant on his own side of the road. Stop. He submits that said evidence clearly indicates that the respondent number 1 was driving his motorcycle on his side of the road, whereas he was knocked by the appellant coming to the wrong side of the road. Stop. He submits that this evidence by the PW1, which is corroborated by the testimony of PW2 and 3, has been taken into consideration by the tribunal. He further submits that the testimony of DW1 and DW2 has been rightly rejected by the tribunal, as there was inherent inconsistency regarding the narration of the incident during the accident by both the witnesses. He submits that whereas the DW1 has mentioned about involvement of a tracker vehicle also in his testimony. However, the DW2 testimony is silent about any tracker vehicle, and the said fact is taken into consideration. And the Motor Accident Claims Tribunal, according to him, has rightly found the testimony of claimant's witness as more trustworthy. He submits that the preponderance of, he submits that in the claim case, in a motor accident claim case, the standard of proof to be adopted is on the basis of preponderance of probability. And the tribunal rightly, by applying the said standard, found the testimony of the claimant's witness as trustworthy. He further submits that as regards the third point raised by learned counsel for the appellant regarding the assessment of monthly income of the claimant as well as loss of earning for 5 months. The testimony of PW6, who was the employer of the claimant, has been considered by the tribunal. He submits that the PW6 has also exhibited the income certificate of the respondent number 1 as Exhibit 6, which clearly indicates that the earning of the claimant was rupees 10,000 per month at the time of the accident. He also submits that the PW6 has also deposed before the tribunal that due to sustaining severe head injuries by the claimant, he had to be absent from duties from 31/7/2000 and what was the year?
Yes, my lord.
Year?
He has mentioned that.
So 31/7/2006 to 31/12/2006.
My lord.
And during such an absence, he was not getting any salary. He was not paid any salary by the employer. He submits that said testimony of the employer had remained unrebutted during his cross-examination. In the learned counsel for the respondent therefore submits that the tribunal had not erred in coming to the conclusion of negligence on the part of the appellant, as well as in assessment of the monthly salary and loss of earning by the claimant, as same is based on the evidence on record. As such, he has prayed for dismissing the appeal. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record, including the records of MSC case number 1136/20 2006, which was requisition in connection with the instant appeal. After going through the memo of appeal and after considering the submissions made by learned counsel for both sides, the points to be determined in this appeal are as follows. As to whether the tribunal, the Motor Accident Claims Tribunal, had erred in attributing negligence which resulted in the accident involved in the aforesaid, in this case, to the appellant without considering the testimony of DW1 and DW2. Number two, whether the tribunal had erred in assessing the monthly income of the deceased at rupees 10,000 per 10,000 without there being any evidence on record in respect of the same.
It should be injured instead of deceased.
Sorry, the injured, deceased or jaga injured. Number three, whether the tribunal was wrong in assessing loss of income of the claimant for 5 months, whereas the evidence on record indicates that he was admitted in hospital only for 17 days. Stop. Next para. On perusal of as regards the first point for determination is question. On perusal of the evidence on record, it appears that the DW1 that is the present appellant, while deposing before the Motor Accident Claims Tribunal, had deposed that while at the time of accident, who is OP number 1? Present appellant.
Yes, present appellant.
At the time of accident, the present appellant took side in the backside of a tracker vehicle, but could not control himself. And it was the claimant is a lady. It was the claimant who hit him with his motorcycle. However, the testimony of DW2, who also claims to be an eyewitness, does not make any mention about tracker vehicle. Whereas the testimony of PW1, PW2, and PW3 are consistent as regards the incident of As regards the narration of the incident of accident, in this case, they have categorically stated in their deposition that accident occurred due to rash and negligent driving of the scooter, who knocked the motorcycle which was driven on his own side. Stop. As such, this court is of considered opinion that the the tribunal, after considering the considering the deposition of claimant's witness as well as the witnesses for opposite parties, rightly relied on the testimony of claimant's witness, as the testimony of defendant's witnesses has had inherent contradictions, and therefore the tribunal did not err on relying upon the claimant's witnesses on the basis of the preponderance of probabilities. So, this court therefore does not find any infirmity in the finding arrived at by the tribunal in attributing the negligence to the present appellant which has caused the accident. Stop. As regards the other 2 points for determination is concerned, though no other 2 points for determination is concerned, the testimony of PW6, who is the employer of the respondent number 1, clearly indicates that the respondent number 1 used to earn rupees 10,000 per month, which also appears from Exhibit 6, which is the salary certificate. It also appears that from (31/7/2006) to 31/12/2006, the respondent number 1 did not attend his duties due to major injuries, and during this time he was on leave without salary, and therefore this court is of considered opinion that the tribunal had also not erred in coming to the conclusion in assessing the monthly income of the claimant at rupees 10,000, and also assessing the loss of income for 5 months, during which period he was unable to attend the duties because of injuries sustained by him. This court therefore finds no infirmity and illegality in the judgment of the Motor Accident Claims Tribunal, which has been impugned in this appeal. For the reasons discussed in view of the discussions made and reasons stated in the foregoing paragraphs, this court finds no merit in the instant appeal. Accordingly, the appeal is dismissed. It also transpires from record the appellant appellant has already paid an amount of rupees 75,000 to the claimant during the pendency of this appeal. He is directed to pay the remaining amount within 2 months from the date of this judgment.
That instruction I don't have.
Payment
Regarding the 75,000.
Huh?
That instruction I don't have, whether received or not, what amount received. It is his submission.
Okay, okay. Remove that. This appeal is accordingly disposed of. The statutory amount deposited by you have deposited any
25,000. Regarding the statutory.
may be returned back to the appellant.
Much of it.
Item 12 and 14.
Yes.
Actually, I pay for an adjournment in this matter today, as my senior RT Mazumdar is out of station last day. So the matter may kindly come up on 5th of March or after 10th of March, any date.
Any objection?
My lord, this matter is but my lord, they did not inform me.
I have contacted.
No, there are other respondents, so I am respondent number 2 in both cases.
No, they tried to mention in the morning also, but they submit that you were not. They tried to contact you. Okay, I'm allowing the.
Let the matter be taken up on 5th of March. No, on 5th I am out of station, my lord. After 10th then.
After 10th, any date, Lord.
Heard Mr. R. Islam, learned counsel for the appellant in MSc Appeal 395, as well as Mr. S.P. Sharma in MSc Appeal 357/2019. Also heard Mr. H. Modia, learned counsel for respondent
Number 2.
Owner.
Owner.
Respondent/owner in both the appeals. Mr. S.P. Sharma has prayed for an adjournment due to personal difficulty of the conducting counsel for the appellant in MSc Appeal number 357/19, Ms. R.D. Majumdar. The prayer is not opposed to by the other sides. Hence, same is allowed. Let this matter. Choose a date.
12th of March.
Let this matter be listed. 12th. Hearing day, when?
Yes, hearing.
Let this matter be listed on 12th of March. Both.
Timing item 10.
Yes.
Lordship, this matter is squarely covered, Lordship. It is a covered case.
Covered by what?
By this Honorable High Court, because no, it was MFA 290, MFA 256. But Lordship, the things is Lordship, the better the court below tribunal, it is heard by a single judge. That is the technical member. But so far the law is concerned, there must be a division bench. One technical member and one
So
judicial.
this is 13 matter. No, what is covered? What this judgment says?
This is, my lord, this in this judgment it is says to remand the case. We are only to heard the case in division bench, not in the single bench. This matter was heard in the trial court in single bench, lordship.
Lordship, the impugned judgment was passed by the learned single member technical here.
Yes.
So the Honorable High Court held in the judgment that the single member cannot adjudicate the matter singly.
Which para? Please read.
53 to 41. I have another decisions of this Honorable Court.
No, the decision, show me
Lordship,
which para you are relying.
thank you. In MFA 90 of 2013, Your Honor, paragraph 7.
No, don't.
No.
No.
There are a number of decisions of this Honorable Court, Lordship, in the same issue.
Lordship, as which I have before you, lordship, given that is para number 4. Lordship, kindly schedule the para number 4. That is MFA 113.
Para number 4 of which judgment?
MFA 113.
MFA 113 you have not given. It is MFA 53.
Okay. MFA 11. 113. I think.
You submit.
Yes, I have given.
113.
This is 113.
113, I have.
Yes, 113, which judgment, which para you are relying?
Lordship, kindly peruse para number 4. 113.
Yes. Railway Claims Tribunal Acts now. Yes, please read.
Mr. De Learned Counsel for the appellant has raised preliminary objection in respect of the sustainability of the impugned judgment and order dated 2/9/2016 passed by the Learned Tribunal on the ground that the said judgment and order was passed by the single member of the tribunal. By referring to section 4 of the Railway Claims Tribunal Act 1987, Act of 1987 for short, Mr. De submits that subsection 2 to section 4 provides that a bench shall consist of one judicial member and one technical member, subject, however, to the other provisions of the Act. And since the impugned judgment and order was passed by a judicial member only, without there being any technical member, the same is not sustainable in law. And therefore, Mr. De has contained that to set aside the impugned judgment and order and to remand the matter back to the Learned Tribunal to adjudicate the matter afresh by constituting a bench comprising of one judicial member and one technical member. In support of his submission, Mr. De has referred to a decision of Honorable Supreme Court in the case of Amulya Chandra Kolita versus Union of India and others, reported in 1991, 1 SSC 181, and also a decision of a coordinate bench of this court dated 8/5/2025 in MFA 90 of 2013, Union of India versus MSC Mahalakshmi Mills. And next para, lordship, it is 6, para number 6. Accordingly, taking note to the submission of the Learned Counsel for both the parties and also decision of the Honorable Supreme Court, Amulya Chandra Kolita Supra, and the decision of a coordinate bench of this court dated 8/5/2025 in MFA 90/2013, the impugned judgment and order dated 0/2/9/2016 stand set aside and quashed.
No, let us read 4. Section 4.
Section 4.
Section 4. The apex court's judgment is also in with regard to this
Lordship,
section 4.
Lordship,
Do you have that judgment?
yes.
Which para?
Lordship, it is para number 3.
Please read.
Lordship, relevant person, I am reading this para number 3, Lordship.
Yes, please read.
1, 2, 3, 4, 5, 6.
Line number
Line number 7, Lordship. Relevant person.
No, read
Lordship.
entire paragraph.
Okay, Lordship.
Yes.
Part 14A containing Article 223A and 223B was introduced in the Constitution by the 42nd Amendment Act 1976. Article 223A enable Parliament to make law providing for the adjudication or trial by the Administrative Tribunal of disputes and complaints with respect of recruitment and conditions of service of persons or of any state or of any local or other authority within the territory of India or under the control of the Government of India or of any corporation owned or controlled by the government. It permits the exclusion of the jurisdiction of all the courts except the jurisdiction of this court under Article 136 of the Constitution. The relevant person, Lordship, the Parliament then enacted the Administrative Tribunal Act 1985, providing for the adjudication of such disputes and complaints through the tribunal established under Section 4 of this said Act. Section 5(1) sets out the constitution of the tribunal and adds that the jurisdiction, powers, and authority of the tribunal may be exercised by bench thereof. Subsection 2 of that section next provides that a bench shall consist of one judicial member, sorry, and administrative member. No provision to the contrary is shown to us. It is therefore statutorily recognized that every bench of the tribunal must consist a judicial member.
So this was judgment in respect of Administrative Tribunal Act. So that analogy was sought to be brought. Okay.
Because section, Lordship, in the yellow section 4(2), yellow section 4(2), the Yellow Claims Tribunal Act 1987, Lordship.
Subject to other provisions of this act.
Yes.
What are the
shall
other?
consist of one judicial member and one technical member.
Read 4. Clause, subclause 4.
Notwithstanding anything contained in the foregoing provisions of this section, it shall be competent for the chairman or any other member authorized by the chairman in this behalf to function as a bench consisting of a single member and exercise the jurisdiction, powers, and authority of the claims tribunals in respect of such classes of case or such matters pertaining to such classes of cases as the chairman may, by general or special order, specified, provided that if any stage of the hearing of any such case or matter, it appears to the chairman or such member that the case or matter is of such a nature that it ought to be heard by a bench consisting of 2 members. The case or matter may be transferred by the chairman or as the case may be referred to him for transfer. So, to such bench as the chairman may deem fit.
So there is an exception.
Exception, but it is not an exceptional case. There has to be, and this judgment, Lordship, which judgment I have given before you, Lordship, in that it is this part also or discussed.
With judgment.
That 113 MFA. This part also discussed, Lordship. One, one, three.
Read.
Para 5, no? Para 5, Lordship.
Please read.
Par contra, MS Sharma learned counsel for the respondent by referring to subsection 4 of section 4 of the Act 1987 submits that as per the said provision, the chairman or any other member authorized by the chairman in this behalf to function as a bench consisting of a single member and exercise the jurisdiction, powers and authority of the claims tribunal in respect of such class or cases or such matters pertaining to such classes or cases as the chairman may by general or special order specify. And as such, she submits that there is no infirmity in the impugned judgment and order.
Next.
However, to a point, para number 5.1, query of this court as to the whether the chairman, while taking up the case, had passed any general or special order.
In the instant case, who has passed the
Technical member only.
Lordship, there is no such order to adjudicate the claim.
by
Chairman has to give the power.
that power?
And
No, in the instant case, the impugned judgment was passed by
Technical
member technical.
technical only,
only technical.
without any authority.
Without any order.
Okay.
That authority is not.
No, it is not mentioned.
Okay. Heard. Where is the impugned judgment? Let us see once.
Page 10.
Oh.
Page 10.
10.
Hello?
10 and the 11 part from 11.
You are representing?
I am for the respondent.
Okay.
Respondent, Mrs. Jain Enterprise. Yeah, member.
An applicant is NF Railways.
Lordship.
In the main case, Lordship, the respondent, that is Jain Enterprise, is the claimant before the Ladek Tribunal, Lordship. He
But
has
Mr. D.K. Day, you are Railway Council or Central Government Council?
No, my lord, the Railway Council.
Heard Mr. D.K. Day, learned counsel for the appellant. Also heard Miss, what is her name?
M. Sharma.
Miss M. Sharma, learned counsel for the appellant, and learned counsel for the respondent. This appeal under section 23 of the Railway Claims Tribunal Act has been preferred by the Union of India / appellant, impugning the judgment and order dated 2/11/2012 passed by the Railway Claims Tribunal, Gauhati bench in original application number OA.I/GHY/2004/0077 within bracket old OA 77/2004 bracket close. Learned counsel for the appellant, Mr. Day, has submitted that the impugned judgment has been passed by the learned technical member, learned member within bracket technical of Gauhati bench of Railway Claims Tribunal only, whereas the requirement of section 4 within bracket 2 of the Railway Claims Tribunal Act, 1987 is that a Railway Claims a bench of the Railway Claims Tribunal shall consist of two members, namely a judicial member and another technical member. He further submits that Section 4, subclause 4 of the Railway Claims Tribunal Act 1987, though empowers the chairman or any other member authorized by the chairman on this behalf to function as a bench consisting of a single member and exercise the jurisdiction, powers and authorities of the claims tribunal. However, in that respect, an order, in that respect, a general or special order has to be passed by the chairman, specifying the classes of such cases or matters which may be taken up by a bench consisting of single member. However, he submits that in the instant case, no general or special order has been passed by the chairman of Railway Claims Tribunal in terms of Section 4 within bracket 4 of the Railway Claims Tribunal Act. He submits that therefore he submits that the impugned judgment is therefore liable to be set aside and to be remanded back for fresh adjudication by a bench of two members in terms of Section 4 within bracket 2 of the Railway Claims Tribunal Act. He submits that the similar issue was raised in another case before this court, before a coordinate bench of this court, in the case of Union of India versus Messrs. Bajaj Steels, within bracket, case number MFA 113/2016, wherein the coordinate bench of this court had remanded the case in that appeal back to the tribunal for fresh adjudication. So, in support of his submission, learned counsel for the appellant has also cited a ruling of the apex court in the case of Amulya Chandra Kalita versus Union of India, reported in 1991, 1 SCC 181. He submits that in the aforesaid case, though the apex court was dealing with the Administrative Tribunal Act 1985, however, Section 4 of the said Act contains similar provision like that of Section 4 of the Railway Claims Tribunal Act, and the apex court held that What was held? Held that in absence of a provision to the contrary, it is statutorily required that the tribunal must consist of 2 members and the administrative member alone could not have heard and decided the matter. Stop. Ms. M. Sharma, learned counsel for the respondent, also agrees to the submissions made by learned counsel for the appellant. Stop. I have gone through the materials available on record and have considered the submissions made by learned counsel for both parties. I have also gone through the rulings cited by learned counsel for the appellant. In the instant case, on a bare perusal of the impugned judgment, it appears that same was passed by a bench consisting of lone member, that is member within bracket technical only, and no order under section 4 within bracket 4 of the Railway Claims Tribunal Act 1987 would be produced by the is not could be produced Katilio. No others was line to production but is there on record which indicates that any authorization by chairman to the member technical to take up the instant case by sitting singly is there. Stop. Since the statute clearly recognizes that the contingency in which a single member of Railway Claims Tribunal can take up the cases for adjudication. However, since said provision within bracket section 4 within bracket 4 of the Railway Claims Tribunal Act has not been complied with in the instant case, the impugned order is liable to be set aside on the ground of lack of jurisdiction by the single member to pass the impugned order. Same is accordingly done. The impugned order is accordingly set aside. The matter is again remanded to the Motor Accident Claims Tribunal.
No, Lordship, it is motor.
Railway Claims.
Sorry. Railway Claims Tribunal, Gauhati bench, with a direction to constitute bench in terms of section 4 of the Railway Claims Tribunal Act and to dispose of the matter again after affording opportunity of being heard to both the parties. Anything else?
Lordship, a time frame must be,
Yes.
because this is a very.
Since this is a very old pending matter of the year 2012, the Railway Claims Tribunal is Gauhati bench is directed to dispose of the matter as expeditiously as possible, preferably within how much time?
6 months.
Within 6 months from the date of receipt of a copy of this order. The registry shall stop, order, stop, next para. The registry shall immediately send the records of original application requisition in connection with this appeal, along with a copy of this judgment to the Railway Claims Tribunal for compliance. This appeal is accordingly disposed of.
Lordship, only one thing is, Lordship, already, we have deposited 73,939 before the registry of this Honorable Gauhati High Court, Lordship. So that part may be released because this
This matter be transferred to the registry of the Railway Claims Tribunal. Okay, the deposit that they have made before the registry of this honorable court, that may be
No.
transferred to the, huh?
that is different, but
No,
Equity deposit.
no, appeal is dismissed.
Dismissal.
It is submitted by learned counsel for the appellant that in pursuant to some direction of this court.
Lordship.
Which order? That the appellant has.
What is the backside, Lordship?
50%.
They have accepted.
Your Honor, they have submitted 50% deposit.
50%.
I am not aware of that part, Your Honor. So.
The learned counsel for the appellant has submitted that in pursuant to the order dated 23/2015 passed by a coordinate bench of this court on 23 passed by a coordinate bench of this court in MC case number 608/2013 in connection with this appeal. The appellant was directed to deposit 50% of the awarded amount in the registry. The said amount may be returned back to the appellant after verification. This appeal is accordingly disposed of.
Published.
Into return detail.
Obliged, Lordship.
Item 14.
May I please know, Lord, I am appearing on behalf of Mr. M. Mondal. In this appeal, my lord, you have challenged the impugned judgment.
Where is the other side?
The name has been reflected in the cause list also.
Who is appearing?
MR Datta.
You are for the
I'm for the petitioner on behalf of Mr. M. Mondal, my lord. Learned counsel for the
petitioner means claimant or insurance.
claimants.
Let them other side appear.
Yes, my lord. And, let another date may be fixed out.
Okay, heard Mr. What is your name?
S. Ahmed.
Heard Mr. S.S. Ahmed. learned counsel appearing for the appellants. When the matter was called on for hearing, none has appeared for the respondents on call. Though the names of Mr. A. Datta and Miss P. M. Datta are reflected in the cause list.
A date may be fixed.
This court is inclined to give one chance to the respondent side.
Lordship, I oblige the Lordship. Respondent Mr. A. Dutta. Counsel for the insurance has already expired, Lordship.
Okay. Who has expired?
Amlan Dutta.
A. Datta. One Miss P. M. Datta is also there.
PM Dutta name is there, but she never appears in.
Who is P. M. Datta?
Why?
Okay. Now what is to be done? The notice will have to
Yes, Lordship.
go to the insurance company. It is submitted at bar that the engaged counsel, that engaged counsel, Mr. Amlan Datta, has expired. Stop. In view of the submissions made by the it is submitted by Miss S.
Sorry, just
Mushari.
I'm before your Lordship.
Okay. That Mr. Amlan Datta has expired. So in view of the above, let a notice be issued to the respondent side. The appellant shall take steps for issuance of notice on the respondent by speed post within 7 days from the date of this order.
Only insurance companies or the other private respondents.
Only insurance company.
Highly
Obliged, my lord.
Returnable on 7th of April.
7th of Obliged, my lord.
Item 15.
May please, your lordship. So this is an appeal against award on account of injury suffered by the claimant. There is only one ground of dispute in this case, lordship. The claimant had suffered permanent disability. And the doctor was examined by the claimant, whose disability certificate has stated that his disability is 63% in relation to the lower limb. His right leg was fractured.
Right leg was?
He had suffered a fracture in the right leg.
Okay.
So the disability certificate in page 137 of the record loss shows that the disability is in respect of the right lower limb only.
Yes.
As per settled position of law, it's Raj Kumar versus Ray Kumar, which has been followed in now almost all cases. The various steps have been given in this judgment. I am passing on a copy of the judgment. In this case, Lordship, this court has very clearly said what is to be done in such cases. The first step that Lordship, the court has suggested in the Lordship may come to para 19 of the judgment. Lordship. Some principles have been summarized in this case. I'm straightway coming to the principles. What has
Yes.
happened in this particular case, Lordship, I'll say what has happened in this particular case. The doctor has also this evidence is there. Doctor is telling very clearly this evidence disability is in respect to the lower limb, right lower limb. And that has been considered by the tribunal as a functional disability of 63%. Now, these concepts are slightly different in the sense the partial disability for a particular limb has to be converted into a disability, partial disability of the whole body. For a particular limb, in this case, his right leg was found to be having a disability of 63%. But for the whole body, because he enjoyed the support of other limbs also, for the whole body, it generally, invariably, even Supreme Court is saying this, turns out to be lower than the particular limb. If the partial disability for a limb is 63%, it invariably turns out that it's lower for the whole body on conversion. It's a doctor who does that. Thereafter, Lordship, with this particular finding, the tribunal applies his mind, Lordship. It's mind. The fact, what is his occupation? Is he office goer? Is he in an administrative job or he does some manual job? And then he arrives at a finding of functional disability.
Of how much?
No, that is his individual judgment, Lordship.
No, what has happened in this case?
In this case, Lordship, that without any conversion to whole body disability, the learner member has just straightway taken that percentage 63%. It could have been any other percentage, but they straightway taken that 63%. There lies the it is not in conformity of the principles of law laid down in various. Lordship, I'll just come to para 19 of this judgment, Rajkumar versus Ajay Kumar.
Yes.
Like this is the judgment that is being followed by. It gives some examples also, various situations, what is to be. Para 20. Para 19, let's say if I may read out also.
Yes.
Let's say this is the same number, para 19. We may now summarize the principles discussed above.
Yes.
All injuries or permanent disabilities arising from injuries do not result in loss of earning capacity. That is number one. Number two is the percentage of permanent disability with reference to the whole body of a person cannot be assumed to be the percentage of loss of earning capacity.
Yes, correct.
Yes. To put it differently, the percentage of loss of earning capacity is not the same as the percentage of permanent disability, except in a few cases where the tribunal on the basis of evidence concludes that a percentage loss of earning capacity is the same as percentage of permanent disability. It's a very exceptional, one of the unusual cases.
Correct, correct.
Thirdly, the doctor who treated an injured claimant or who examined him subsequently to assess the extent of permanent disability can give evidence only in regard the extent of permanent disability. The loss of earning capacity is something that will have to be assessed by the tribunal with reference to the evidence in entirety.
Right.
The same permanent disability may result in different percentages of loss of earning capacity in different persons.
Depending upon what he does.
Depending upon the nature of profession, occupation, job, age, education, and other relevant.
Okay, right.
Now, look in para 20, Lordship, some judgments have been, some situations have been discussed. Lordship. It's very illuminative, illustrative, and illuminative.
Yes.
In para 20, Lordship, I'll just not go through the entire. In para 20, the injured as a workman is at 30 years, earning 3,000 per month. As per doctor's evidence, permanent disability of the limb as a consequence of the injury was 60%. And consequent permanent disability of to the person was quantified as 30%, that is of the whole body. 60% has been converted into 30 whole body, 30%. The loss of earning capacity is, however, assessed by the tribunal as 15% on the basis of that evidence, where because the claimant is continued in employment, but in a lower grade. This is one situation, Lordship. This is just discussed to give an idea how it made 60% for a limb has been converted into 30% for the whole body. And from that also, tribunal came to a loss of earning of 15%. illustration B, that was illustration. Illustration B is again under, injured was a driver aged 30 years, earning 3,000 per month. His hand is amputated and his permanent disability is assessed at 60%. He was terminated from his job and he could no longer drive. His chances of getting any other employment was bleak, and even if he got any job, his salary was likely to be pittance. The tribunal therefore considered therefore assessed his loss of earnings as 75%.
On what basis 75 was assessed?
No, because it's amputation case.
No, what was the basis?
It's just
Why 75? Why not 65?
What was left to the discussion of the tribunal.
Why not 85?
No, this just I don't know why, Lordship, but it just discusses some situations. These may not be actual fact cases. Lordship. It is just discussing what can happen. It says 60% disability, even as per WC Act, amputation of hand.
So these illustrations only show
Yes, Lord. So that
the loss of earning capacity is to be assessed by the tribunal
tribunal from
after considering age,
yes,
job, and how much disability
yes.
comes into way.
But the basic starting point for that inquiry by the tribunal is the disability assessed by the doctor. That is his plank on where he.
In the instant case, disability was 63% of the right lower limb.
Right. That was not converted into the yellow, but that was the doctor's job.
It was not converted into what?
Whole body disability. It says that when it was in the illustration A, when it was 60%, it came down to 30%.
No, why whole body disability is required?
That is the reason.
The question before the tribunal is that a person was earning a particular amount. How much loss of earning will be caused due to the disability faced by him? Only that has to be assessed.
That is there is no dispute about it. But before that, it says that a person may be disabled, my right hand, left hand may be disabled also to the extent of 60% of the use of my left hand.
Okay, in this case, in this appeal, what is your submission?
My submission, Lordship, as well, I'm just strictly submitting as per the law, Lordship. The disability of the right leg, not two legs, because he still has the other leg. Disability of the right leg has been assessed as 63%. Now, law requires that this should be considered it may be disability of the right leg, but does it reflect the total disability of the person taken as a totality? What is the disability of the whole body? That has to be converted into a percentage of disability of the whole body. Also. This entire judgment is about that only.
Where is that requirement?
Para 17, let's say. I'll read out para 17.
Yes.
If a doctor giving evidence uses medical terms, the tribunal should instruct him to state in addition, in simple non-medical terms, the nature and effect of the injury. If a doctor gives evidence about the percentage of permanent disability, the tribunal has to seek clarification as to whether such percentage disability is the functional disability which refers to the whole body, or it is only with reference to the limb.
Okay.
This query was not made. The man may not have 63%. He is not disabled to the extent of 63% in relation to other limbs. He can still carry on other things in spite of a, say, disabled left hand. His right hand may be intact, two legs are intact. He can still do a lot of other things. This is the reason why, Lordship, there is a differentiation between a permanent disability of the part and disability of the whole.
And what happened in this case?
In this case, Lordship, I'll read the judgment. That once vital step was missed, that is my Lordship. I'll read para 7. In fact, the judgment is discussed in para 16.7, the medical evidence of the doctor. May I read from para 16 also? That will make clear what was the doctor's evidence in this. Para 16 of the judgment.
Yes.
The claimant has examined Dr. Sujata Hazarika, PWT, Associate Professor in the Department of Physical and Medical Rehabilitation, KMPH, a member of the Medical Board representing Physical Medicine and Rehabilitation. According to her, Exhibit 5 was issued by Joint Director of Health Services, Kamrup Amin Gaon, in respect of one Deepak Bosha who sustained physical impairment in relation to his right lower limb. And the disability is assessed to the extent of 63% in relation to right lower limb and not to the whole body. The percentage has been assessed clinical and physical examination of the injury, followed by guidelines issued by the Department of Social Welfare, Government of India. Exhibit 5.1 is her signature. She represents physical medicine and rehabilitation in the board duty constituted for the purpose of issuing disability certificate under Rule 4 of the scheme provided by the central government in consultation with the state government social welfare department. The disability is permanent in nature and the percentage is about 42 years and the case is of impairment of locomotor. There are 17 also. In a cross-examination, she has deposed that they have not opined any clause regarding reassessment of disability after a particular period of time. She has not examined the patient personally, either at her chamber or in hospital. She assessed the disability only on the extent of the ground relating that found in the person of the injured. There is less chance of healing, but provided vigorous exercise, sentence appears to be also incomplete. But provided vigorous exercise, maybe he might improve. The disability relates to particular organ and not to the whole body. It's kind of reiterated in the earlier. She has not submitted the copy of the reading on the basis of which disability is assessed. She denied the suggestion that disability is assessed on the higher side and is prepared without following any guidelines in a routine manner. From the evidence, next paragraph, from the evidence on record, it reveals that the claimant Deepak Bosha suffered type 2 compound fracture, both bone legs, type 1 compound fracture, right of the same leg, femur, and fracture of the right humerus following the disability. The disability is permanent. The percent of disability is, this is the tribunal's finding. Permanent percent disability is confined to the particular limb and not to the whole body. In Exhibit 5, it is clearly mentioned disability was 60% and permanent nature. It is settled rule of evidence that the contents of a document cannot be contradicted by ocular evidence. Later, there is no contradiction, Lordship. In the 137 may be seen, Lordship. The doctor had contradicted the document. Therefore, considering the evidence of PW2, Dr. Sujata Hazarika, Associate Professor, Physical Medicine, and documentary evidence Exhibit 5, I feel it's safe to accept functional disability as 63% as a whole of the OP industry as a whole, as the OP insurance company failed to rebut the evidence PW2 in respect of person disability by introducing any. No, so in this case, the whole aspect has been missed out. There's no attempt to convert partial disability of the limb into the disability of the whole body. This particular exercise, Lordship, seems to have been missed out. Member has straightway proceeded to calculate on based only one finding. That second finding was required. That is my, I will not go beyond that because my ground is up to that particular part.
No. What was the impact of this observation? How the
is calculated now. Suppose the income of the particular person was 10,000. If it is functional disability 63%, then that loss of income will be presumed as 6,300. If it is 30%, then loss of income will be presumed as 3,000 lordship. That is the impact. This impact is directly an impact on the earning capacity.
So
Whatever
you,
he was earning, that means this disability is reduced to has reduced that income to that extent.
so
It
you're
impacts the
submitting,
income to 63% as per this year. But my humble submission is, if it was converted into a whole body, it would have been less. That's my very humble submission.
okay.
That disability of the whole body has to be considered.
So
Maybe
therefore,
never
the,
again,
therefore what?
definitely medical opinion may be taken. It may be remanded for the determines of the particular part only, not for 1 month, 2 months. A doctor may be again here. So what can be the effect of the disability on the whole body? That I'm asking for a year of that part only.
What the claimant was doing,
He is a vegetable vendor.
vegetable vendor.
I'll leave that part to the tribunal also, but without this missing link ought to be filled up, Lordship. That unless the whole body percentage is calculated, he cannot do it.
No, whole body is not necessary. It may, the purpose is to assess the loss of his earning capacity.
But for that medical evidence is necessary.
Yes,
Medical evidence that the whole body has suffered this percent of disability. Disability is not linked to, functional disability is not linked to just on one particular limb. As a person, how has it affected his person as a whole? How so it just, otherwise they would, Supreme Court would not have given so many illustrations. Either way. First, that has to be ascertained, then only he can proceed, Lordship. Just like Lordship, in worksman compensation, the doctor has to assess the loss of earning capacity. It's not given to the commissioner. Based on medical evidence.
okay.
Here,
This is your submission.
that is my Lordship. Without conversion, that conversion from partial disability to
So
whole
your
body
prayer is to remand back the matter to tribunal.
That's only for this particular part. So it may again come back to the after determination, it will come back to the High Court again.
No, without,
Not saying,
even if suppose this court accepts your submission
and if the court, Lordship,
without remanding, whether
No,
on the
sir.
basis of,
said that point, Lordship. This court can also do it.
no, what is your submission?
My submission, I said, this is necessary to have that medical evidence. Lordship. Entire thing is based on medical evidence.
Okay, okay,
That
yeah.
whole body disability is a medical evidence.
Yes, yes. After lunch,
Yes.
at 2.
At two.
At 2 we'll continue.
Okay.
Mr.
Yes, Sarkar Lordship.
S. Sarkar, learned counsel for respondent. Learned counsel for the appellant has prayed for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed
So 2 weeks any,
on 26th of March.
May it please your Lordship.
Yes.
My lord, with a profound apology, my lord, in item number 26, my lord, it is an alia appeal by the IIT Gauhati, my lord, item number 26, my lord. My lord, I was in courtroom number 1, my lord, we missed that matter, my lord. If it can be taken as the last matter, my lord, as it today, my lord, there is some urgency there in this case, my lord. It's an
Item number 26.
my lord, I'll tell very brief.
The order has been uploaded. What is the order?
My lord, if it can be, as a, my lord, tomorrow, my lord, if that can be matter may be taken up, my lord. This is
Date change kar dena. Tomorrow we'll take it up.
deeply obliged, my lord.
Yes. Yes.
My lord, in this case, claimant has sustained type 2 compound fracture in both the legs, both the bones of the right leg. Then type 1 compound fracture of femur, that is of the thigh, and also fracture of the humerus hand. After the Dr. Silva Hazarika, who adduced evidence, she told that after seeing physically the injured person, he has given the disability, he assessed that disability. My lord, the claimant he cannot walk now, and he's this also damaged, hand also damaged, though it is not mentioned in the disability certificate.
Yes, disability certificate is in respect of right
Lower
limb.
Right lower limb, but his whole right side is my lord disabled. So his actually disability should be 100% because his complete right side is disabled. Right. And if, my lord, on the other side, if one person has 63% disability in the lower limb, how can he stand? How can he walk? He is a vegetable vendor. He bought the vegetables from the field and sell in the market. How can he do the things? How can he do the business? He has his family and he has to manage his livelihood. There is, my lord, one judgment is there. Two judgment is there. Sorry. 2018 in 2018 to TSC, page 14, madam, Supreme Court decision. My lord, here both the hands of the claimant was not amputed, damaged. So it was, disability was assessed 90%. But Supreme Court accept it as, increase it as 100%, my lord.
No, in this judgment, which para you are relying?
My lord.
Which
In
para?
number, first, page number 15, my lord, in the head. Page number 15.
Page number 15 of.
15 in the upper side, my lord.
Yes.
Yeah, number 9. It is in the sentence number, my lord. It is further. High Court enhanced the same by the amount of rupees demand. Further enhancement sought.
His submission is different.
Yeah,
Yeah.
I know, my lord. He said that functional disability regarding.
Yes.
But if, my lord, both lower limb is disabled.
In this case, only one lower limb has been disabled.
No, one lower limb, but right side, my lord.
Right side.
How can he stand and how can he walk with the left side?
He can
And
walk.
But, he has sustained fracture in hand also and in the thigh also, my lord. The complete right side is disabled. How can he stand and how can he walk and how can he do business, his business?
Okay.
It means that, my lord, the injured should have been amputated his leg to get the compensation amount by taking the amputation. That is what they mean is that, my lord.
No, they don't mean that. They are only saying the tribunal was not right in assessing the functional disability to the extent of 63% without there being any finding of the doctor as regards the total disability.
My lord, there is no
What is your
doctor.
response?
There is no doctor in the Mahalo tribunal to examine all this. They have not examined, no doctor. That is their fault, my lord. They have not examined any doctor to find out the functional disability. I have reduced the evidence of Dr. Sujata Hazoika, who have issued the assessment and disability certificate.
But the doctor which you have examined, she herself has deposed that the disability of 63% was only in respect of
Permanent disability in respect. And she also stated that there is no chance of healing the disability, injury.
okay. Anything else?
So my lord, in my submission is that, my lord, 63% is lower. It should be higher, disability should be higher, but as I have not filed any cross-examination, cross appeal, so this appeal should be not allowed, my lord. My submission is that.
Anything else?
So I've given two judgments, my lord. Yes.
You have given one judgment only.
Three judgments, my lord. One is 2014 3 SCC and one is 2017 TSC.
2014 3 SCC.
14 3 SCC and one is.
Which paragraph you are relying?
My lord,
In 2014 3 SCC.
yes.
Why you have submitted this?
This is submitted because my lord.
To emphasize what?
My lord, here in the paragraph number 210, in the first paragraph, my lord, it is stated that the injured was paralyzed. So he was 100% disability.
But your case is different.
My case is same, my lord. He cannot walk, cannot stand in one leg. My case is same, my lord. In
And third judgment?
this Gauhati High Court, my lord. But 2017 4 Gauhati High Court.
Why you are relying?
This is also that is due to damage of spinal cord. That was 100%, 100% disability. So my case is, I just want to say that my case is same, my lord, because his lower limb is not functioning. Not only lower limb. Complete right side is not working. He cannot walk, cannot stand. And at the time of argument, they have not pleaded this, my lord, regarding functional liability, loss of income.
Okay.
So my submission is that, my lord.
Anything? Any reply?
Since some environments has been made on factual aspect. There's no evidence that he cannot walk, he cannot do anything. There's no evidence. I have not read evidence. The claimant herself has given a photo in a good record that even after the injury which a plaster, he was standing.
My lord, that he cannot.
Please allow me to.
Yes, sir.
So
How much compensation was paid?
9,92,000.
992.
And 50% they have given, my lord.
You have already received 50%.
They keep
Yes, anything.
being made out that he cannot walk, it's so serious. Photograph submitted by the claimant in the record. He was standing with plaster up to the knees, not even the femur lordship. Doesn't cover a femur, plaster up to the knees only. Just averring to the facts, since it doesn't made, it probably is not so serious that it, as it is made out to be lordship. So in any case, my point is that without that medical evidence, how can that be?
Okay.
And also that this judgment has been followed by almost in all the disseminated cases. This is practically like a touchstone for you. So without medical evidence, lordship, which is not even given to even worksman company commissioner, he has to go by the doctor's certificate. That forms the basis for his assessment. Here also doctor's certificate is the basis.
No, not only doctor, this is disability handicap certificate is from the Joint Director of Health, my lord.
I refer to the page 137. There's a disability certificate. There it said very clearly written only in relation to the E. In fact, I just rely on under judgment. A part of it, because these two judgments are being cited universally as a recommendation of full bench also. This should be followed. This is being followed. This is under. I'll pass on this judgment now. How it's not so irrelevant. It does not. It's Arvind Kumar Mishra versus New India lawsuit. I probably have one copy. I'll read this para and pass it on to you.
Who said that?
The applicant, may I read lordship, this particular judgment also?
Yes.
I do not have.
नहीं करेंगे तो लिखे छठ वर्ष के আসলে কোনো পরিস্থিতি
Where is the disability certificate?
Page 137 lordship.
On the trial court records.
Trial court.
137 is something else.
Photograph of the claimant is also in the LCR. It is given at the time of filing the claim petition.
137 is not there. We exhibit, which is the, what is the exhibit number?
Number would be 5B.
Okay. Okay, what else?
Exhibit number is 5, lordship. Exhibit 5. It's on both sides. Lordship, I'll notice the number is 137. And LCR. Same thing, lordship, what we have been saying, it's very clearly written, 63% in respect to the value.
Okay, what else you want to refer, Anand?
I'll just give two citations that why this is being followed here. So this is also under judgment on the same line. This is a judgment just preceding that Rajkumar Ajay Kumar, and these two together are being cited by in all cases. The appellant at the time of accident was a final year engineering student, mechanical student in a reputed college. He was remarkably brilliant student, having passed all his semester examination in distinction. Due to a sedent, he suffered grievous injuries, remained in coma for about 2 months. His studies got interrupted as he was moved to different hospitals for surgeries and other treatment. For many months, his condition remained serious. His right hand was amputated and vision cerebral. Multiple injuries finally led to 70% permanent disablement. He has been rendered incapacitated. I'll come to reading. Para 14 lordship. I'll just read out the long para. Since he suffered 70% disability, the future earnings may be discounted by 30%. Accordingly, we estimate the facts and multiplicand should be there. So, lordship, in just to establish my point, that it may be different. Even in such cases, it was considered because after he recovered, maybe it was down to 30%. I'll just pass on this.
No, on what basis it was? lowered to 30%.
Long para loss, I have to read out the whole para.
Okay, you mark it.
About para 13 and 14 loss.
Okay.
I marked it, marked this.
Heard Mr. R. Goswami.
My lord, here in Dr. Sujata Hazoika, she stated in her evidence that she assessed the disability only on the basis of ground relating that found in the person of the injured. She saw the person, my lord, and seeing the person, she has issued along with the treatment certificate.
Okay, from where you are saying that he suffered injuries on upper limb also, right upper limb?
Upper limb means, my lord,
Is there any
yes,
material?
my lord. There is a evidence of my lord, discharge certificate. Discharge certificate, exhibit 2.1.
What it says?
What it type 2 compound fracture both bone, type 1 compound fracture femur, and fracture shaped humerus. All this, so all are right side. He was stayed in the hospital for 2 months, my lord, more than 2 months.
Fracture of humerus.
Humerus, my lord.
Humerus
This
is
the bone
this.
from shoulder
The
to
funny bone.
elbow. This bone is.
The funny bone is called.
This is the humerus. My lord. This bone is humerus, my lord.
Okay. But Mr. R. Goswami, the learned counsel for the appellant, also heard Miss D. Roy, the learned counsel for the respondent. All the respondents or respondent number 1?
Respondent number 1.
Learned counsel for respondent number 1. This appeal under Section 1873 of the Motor Vehicles Act, 1988, has been preferred by the appellant, namely Messrs. Liberty General Insurance Limited, impugning the judgment and award dated 17/1/2021 passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro at Gauhati, in MSC case number 652/2017. Stop. Whereby an amount of rupees 9,92,300 was awarded as compensation to the respondent number 1, and the present appellant was directed to pay the same. Stop. The facts relevant for consideration of the instant appeal, in brief, are that the claimant, within bracket, respondent number 1, had approached the Motor Accident Claims Tribunal number 3, Kamrup Metro, Gauhati, by filing an application under Section 166 of the Motor Vehicle Act, 1988, seeking compensation for the injuries sustained by him as a result of motor vehicular accident which occurred on 24/11/2016. Stop. It is stated by the claimant in his application before the Motor Accident Claims Tribunal that on the aforesaid date, while he was coming from Bongsar towards his house at Gonmo by walking, he was hit by a motorcycle bearing registration number AS 25H1854 within bracket Honda Due, causing serious injuries on his person. Stop. Immediately after the accident, the claimant was taken to Gauhati Medical College Hospital, where he was admitted and later on discharged on 3/1/2017. The claimant / respondent number 1 sustained head injuries as well as type 2 compound fracture of both bone in the right leg, type 1 compound fracture of femur, fracture shaft of humerus right. Stop. The present appellant as opposite party number 3 in the claims case contested the claim by filing written statement and denied its liability. To pay any compensation to the claimant / respondent number 1. Stop. Next para. Upon pleadings of both the parties, the Motor Accident Claims Tribunal framed following issues. Court issue from A, marked as A, at page 10 and 11. Stop. During the course of inquiry, the claimant examined himself as PW1 and exhibited certain documents. He also examined Dr. Sujata Hajurika as PW2, whereas the insurance company / opposite party examined adduced no evidence. Stop. Ultimately, by the judgment and award which has been impugned in the instant appeal, the Motor Accident Claims Tribunal allowed the claim petition and directed the appellant to pay compensation to the claimant in the manner as already described in the foregoing paragraphs. Stop. The learned counsel for the appellant, now Mr. R. Goswami, the learned counsel for the appellant, has submitted that though several grounds of appeal, several grounds had been stated in the memo of appeal. However, the appellant is mainly pressing on the ground that the Motor Accident Claims Tribunal number 3, while passing the impugned judgment, had erred in considering the functional disability of the claimant to the extent of 63% as a whole. Stop. He submits that while arriving at the say 63% as a whole. Stop. He further submits that the tribunal has also erred in assessing the loss of earning capacity of the claimant to the extent of 63%, ignoring the testimony of the PW2. Stop. He submits that the deposition of PW2 as well as the disability certificate which has been exhibited as Exhibit 5 clearly indicates that the claimant suffered physical impairment in relation to his right lower limb only, and the disability which has been assessed by the doctor, that is 63%, was in relation to right limb only and not of the whole body. He submits that the tribunal has erred in not following the guidelines issued by the apex court in this regard in the case of Rajkumar versus Ajay Kumar and another, reported in 2011 1 SCC 343. He submits that the disability he submits that the percentage of disability indicated in the Exhibit 5 as well as in the testimony of the PW2 cannot be regarded as the percentage of loss of earning capacity, as the loss of earning capacity has to be assessed separately on the basis of factors like nature of profession, age, education, and similar other factors. He further submits that In the instant case, the PW2, that is the doctor who examined the claimant, has categorically deposed that the percentage of disability indicated by her in her testimony is in relation to right lower limb of the claimant and not to the whole body. He submits that under such circumstances, it was incumbent upon the tribunal to seek clarification as to whether such percentage of disability is functional disability with reference to whole body or whether it is with reference to a limb only. He therefore submits that the tribunal was wrong in assessing the loss of future earning capacity of the claimant to the extent of 63%, and thereby giving an additional compensation against that component to the extent of rupees 7,93,800. He submits that since the tribunal, while assessing the extent of permanent disability suffered by the claimant, has not complied with the guidelines of the apex court, this matter may be remanded back to the tribunal with a direction to comply with the directions of the apex court as indicated in the aforesaid judgment, and thereafter pass a fresh award. He also submits that learned counsel for the appellant has also cited a ruling of the apex court in the case of Arvind Kumar Mishra versus New India Assurance Company Limited and another, reported in 2010 10 SCC 254. Stop. On the other hand, Miss D.D. Roy, the learned counsel for the respondent / claimant, has submitted that the Motor Accident Claims Tribunal has committed no illegality or irregularity in assessing the functional disability of the claimant to the extent of 63%. She submits that since both the both the bones of lower limb suffered from since the cutoff. Where is the injuries? Since the claimant suffered from type 2 compound fracture of both bones of right leg and type 1 compound fracture of femur right, as well as fracture of shaft of humerus right, followed by disability. He was totally disabled on his right side. And she submits that the tribunal, by assessing the loss of functional disability to the tune of 63%, has in fact assessed the disability on a lower side. She submits that the claimant was a vegetable vendor by profession, and after the accident he is unable to stand on his own legs, and also there is a difficulty in movement. She also submits that this court no. She also submits that the functional disability ought to have been computed at computed more than 63%. However, since no cross appeal has been filed by her, she is not pressing on the said issue. In support of her submission, learned counsel for the respondent has cited following rulings: Jagadish versus Mohan and others, reported in 2018 2 TSC 14 within bracket SC. Sanjay Verma versus Haryana Roadways, reported in 2014 3 SCC 210. George Vanlal Finga versus Srimati Lalbyak Loangi and others, 2017 4 TSC 912 Gauhati. Stop. She therefore submits that the appeal filed by the present appellant may be dismissed. So I have considered the submissions made by learned counsel for both sides and have gone through the materials available on records, including the records of the MAC case number 652/2017, which was requisitioned from the concerned Motor Accident Claims Tribunal. I have also perused the judgment cited by learned counsel for both sides, in support of their respective submissions. ... I'm reserving the judgment. I'll go through the citation and pass the remaining portion. Heard so and so. Hearing concluded. Judgment reserved.
Problems.
বেশি টাইম না লাগে।
What is this?
Substantial question law, substantial question of law involved in this case is that, let's say, whether the learned commissioner was justified to consider the ways of the decision.
When it was formulated,
Let's see,
when, by which order it was?
let's see. I ordered it at 10/5/2023. At the time of the admission of the appeal.
Yes, please read.
Whether the learned commissioner was justified to consider the wage of the deceased workman at ₹12,000 per month and to compute the compensation accordingly, inasmuch as per Gov notification which was in force at the time of accident, the statutory salary ceiling for any workman was ₹8,000 per month.
Okay.
In this case, Lordship, although there was no evidence by the employer regarding the income of the deceased, on the oral evidence of the claimant, the monthly income of the deceased was considered at ₹12,000. Employer was not examined, Lordship.
Yes.
Lordship, as per the notification at the time at course, Lordship, the
Whether that notification was brought into evidence. By-
it is not required, Lordship, as per the act, Lordship,
Well, what is the evidence of?
as per the commissioner, as per follow the notification, Lordship. Because the
No. What is the evidence?
No evidence.
Lordship,
Evidence of what is this?
the notification as per section 4, Lordship, amount of section 4 of the Employment Compensation Act, Lordship. Employees Compensation Act, amount of compensation. Subject to the provision of this act, the amount of compensation shall be as follows, namely, whether death result from the injury and an
No,
amount equal to.
what you are reading, Employees Compensation Act. there. Where are you reading? Section 4.
Section 4.
Yes, read.
Amount of compensation, subject to the provision of this act, the amount of compensation shall be as follows, namely, where the death result from the injury, an amount equal to 50% of the monthly wages of the deceased employee multiplied by the relevant factor. Then Lordship will find insured by act in the page number 14 in the Lordship, Bear Act, Lordship. 1, 2 in the
What you want to refer?
inserted by the
Where?
in the page number 14, Lordship.
No, in which provision it has been inserted?
It was inserted by act.
What was inserted?
Income, Lordship. What was the maximum income should be considered by the.
No, where are you referring?
In the Bear Act, Lordship.
Bear Act, which provision?
In the
Section, which section, which provision? Section 4?
Section 4.
Section 4 have many clauses.
Section 4A.
Where death results from injury. Yes.
Inserted by Act 45/2009, Section 7C, with effect from 18/1/2010. The central government has specified for the purpose of subsection 1, 8,000 rupees as monthly wage, 5 SU 125(8)E, dated 31st May 2010, with effect 31/5/2010. So.
No, where are you reading? I am not getting anything.
In the page number in my book.
You are referring to section 4, clause A.
Yes, let's see.
Then again, where are you?
Can I see the?
What you want to submit? Make it.
As per the act, as per the amendment, the earlier 4,000 was enhanced to rupees 8,000.
Where?
Probably lots of it is the new act after.
No, read the provision of the act. Amount of compensation. Read A. You are referring to 4A.
4A.
Read 4A what it speaks.
With the death result from the injury and amount equal to 50% of the monthly wages of the deceased employee multiplied by the relevant factor.
Okay.
Then Lordship will find in the explanation, Lordship, Lordship have to find a Lordship 2A in the next page, Lordship. 2A.
What 2A? Explanation 2A, section 2A, subsection 2A.
Lordship, section 2A.
Lordship, I think I may be clarified. Lordship.
Yes.
As because Lordship, this act is old. Whatever my planet friend is referring, this is old act. And now after amendment, whatever code is was saying, there is a new act. So that is as amendment has been done. And my learned friend says main contention is that the before amendment 2009, this amendment was done. After amendment, the notification has been given. The state government has been notification has given. There's the monthly wage at 8,000, and earlier it was 4,000.
No, Mr. Bhatto is referring to the provisions of the Employees Compensation Act. So you have to take the code to that provision. For that, you have to specifically mention that this provision, section 2A proviso.
Yes,
so where should I go?
In this act, that provision has been deleted. and a new provision has been inserted. That's why Lordship, Lordship here in the, Lordship kindly see 1B. Next page, Lordship, next
One.
page, 1B.
Where temporary disablement.
No, Lordship, no. No, Lordship, section 4, 1. Then Lordship, again, Lordship, next page, Lordship kindly, 1B. Next page, Lordship.
No, section 4 has clause A, clause B, clause C.
D,
and clause-
after D, Lordship,
1B, Lordship.
after D,
Or 1B.
after D, Lordship,
1,
B.
1B.
Lordship.
yes.
So in this way, you have to refer to sections.
Cases.
Till now, you are referring to, you have to refer section 4, 1, capital B. I would have directly gone to that provision.
Lordship, Lordship, Lordship.
Yes.
The central government may by notification in the official gazette specify for the purpose of subsection 1 such monthly wage in relation to as employee as it may consider necessary.
Yes.
Then in the Lordship, in the last part, Lordship will find inserted by Act 45 2009 section 7C with effect from 18/1/2010. The central
Lordship,
government
footnote in the last Lordship, footnote. My learned friend is referring in
Okay, what you want to submit, make your submission.
The central government has specified for the purpose of subsection 1, 8,000 rupees as monthly fine as soon 125(8)E dated 31st May 2010 with effect from 31/5/2010. Lordship, in this case, the accident took place in the year 2019. Lordship, finally see the judgment,
2000?
19, Lordship.
2019. Para number 3, page number 9. Given para is page number 5. The fact of the case is that on 19/10/2019 at about 4:10 p.m. the said vehicle bearing
No, no,
registration
just a minute, just a minute. Where are you reading?
in my memo appeal, page number 9.
Yes. Para?
Para 5.
Yes, what you want to say?
The brief fact of the case is that on 19/10/2019 at about 4:10 p.m. the vehicle number bearing registration number so-and-so came from the Pagamara with loaded sand and after unloading the sand at Brahmachinele College Road opposite of Grameen Vikas Bank, and when the said vehicle suddenly ahead of few feet with rash and negligent manner for egress from there by the said driver and contacted the vehicle with live wire for the electricity, and the said vehicle was electrified as such the Clemenson was fall down from the said vehicle as he was electrocuted, and immediately he was rushed to the Boroma Public Health Center by the presence of public, and he also referred to Musalpur Civil Hospital, Musalpur for better treatment. But in the meantime, his son died on the same day at the civil hospital, had conducted and prepared the postmortem report. Accordingly, an FIR was lodged before the officer in charge of Boroma Police Station, which was registered in Boroma PS case number so-and-so, under section so-and-so of the state. So there was no dispute that this was died in course of his employment. Only disputed is that regarding the monthly salary. Lordship. Next page, page number 10. The written statement of the opposite party number on the owner cum driver of the involved vehicle to that effect that the present claim is not made in the present form of the case under the eye of law, and as such this petition is liable to be dismissed. That the facts given in the claim petition are true, but the claim petition is made for the executive claim and the same is not tenable in law. That the answering hospital does not admit anything stated in the claim petition which is specifically admitted herein. That the opposite party number 1 is innocent and denied the allegation made upon him. that the statement made in paragraph number 1 of the claim petition answering opposite party has nothing to comment, that the statement made in paragraph number 2 of the claim petition the answering opposite party has nothing to comment. Moreover, opposite party must state that claimant was appointed as handyman of the vehicle bearing registration number so and he was registered owner of the vehicle having update tax paid registration certificate. Then let's say that the statement made in paragraph 3 of the claimant that the answering opposite party has nothing to comment. He further stated that it is true fact that the claimant's decision has received salary 9,000 only per month, along with rupees only per day from the answering opposite party as daily allowance. The answering opposite party has been made payment of bonus, festival allowance, etc. That as regards the statement made in paragraph 9 for the answering opposite party has nothing to comment. He begs to state that on 19/10/2010 at about 4:10 p.m., the said vehicle bearing registration so and so came from Pakamara with luggage and after loading the same at Boroma Tineri College Road opposite of Gramin Vikas Bank. And when the said vehicle suddenly forward in few feet for execution from the spot and suddenly contacted the vehicle with live wire of the electricity. As a result, the said vehicle electricity and Clemenson fall down from the said vehicle as he was electrocuted and immediately he was rushed to the Burma Public Health Center by the opposite party number 1, as well as the presence of public. He also referred to Mosalpur Hospital at Mosalpur for better treatment. But in the meantime, he died. Accordingly, postmortem conducted at the said civil hospital and prepared the postmortem report. And due to this misunderstanding, an affair lost before the officer in charge of Boroma Police Station by the claimant. Accordingly, the same was registered being Boroma PS case number under section 279-304A IPC. In this regard, the opposite party number back to state that he had driven the said vehicle with full carefully and there was no rational negligence having valid and effective driver's at the material period of accident by DL number issued by DTO null by Assam valid that as regards the statement made in paragraph 5 of the claim petition, the answering officer has nothing to comment. The release of any vehicle bearing registration is the insured by the United India Insurance Limited bearing policy number which was valid till 17/11/2019. As per term and conditions, the insurance company will be liable for any compensation damage for bodily injury to any person for use of the motor vehicle as such. Regional head office of the United Insurance Limited is liable for make payment of compensation. Hence, the name of the claim petition should be taken up from the party. And as regards the statement made in paragraph 6 of the claim petition, the answering officer will beg to state that claimant Sean died due to receive personal repairs hurt by the accident arising out of an in course of his employment and being of the alias of an vehicle is insured by the insurance company that is opposite party number 2, having all his valid documents like insurance policy, driving license, registration certificate, permit, issued in the name of answering officer by the RTO Karbi Anand Difu, which is all Assam permit having the fitness certificate up to issued by the RTO Karbi Anand Difu, tax payment received and so and so. As such, opposite party number is not liable to make any payment of commission if sure even say may be liable to commission by the opposite party.
No, what you want to emphasize?
That's it. My argument that the daily allowance which was paid by the employer to the deceased is not part and parcel of the waste. It cannot be considered as part and parcel of the waste. And second thing is that at the as part of notification, the learned commissioner ought to have considered the monthly wage of the deceased as rupees 8,000 instead of 12,000. Since the maximum ceiling at that time was rupees
No,
8,000.
where is the maximum ceiling?
Yes, Lordship.
Rupees 8,000, Lordship.
No, but where is the word maximum ceiling?
Yes, Lordship.
It was stated that
It is not, it does not state that this is the upper ceiling. This is the lower limit.
it was not stated that it was a lower limit, Lordship. It is not stated, Lordship.
Where it is stated, it is the upper ceiling.
Lordship, I am to place two judgment, Lordship, on this point, Lordship.
Yes.
Okay, kindly see the para number 24.
Which one?
Judgment K. Siboraman and others versus
Para
Para 24.
24.
24. The question before the bench in Vasala was clearly whether an amendment to section 4 and 4A of the 1923 Act enhancing the amount of convention and the rate of interest would be applicable to cases where the accident took place prior to the coming into force of the amendment. The bench held that the benefit of an amending an act enhancing the quantum of compensation would not apply to accident that took place prior to the coming into force of the amendment. Though learned amicus curiae sought to rely on the two judge bench judgment of this court, it is sufficient at this state to note that subsequent judgment of this court, Oriental Insurance Corporation versus CB George, 2012 SCC 540 noted that the judgment is contrary to the judgment of this court in Pratap Narayan Singh and Vasala and hence non-binding precedent. The 1923 Act is a social beneficial legislation and the provision of the amendment thereto must be interpreted in a manner so as not to deprive the employees of the benefit of this legislation. The object of enacting the Act was to ameliorate the hardship of economically poor employees who were exposed to risks in work or occupational hazard by providing the zipper and sticker machinery for the compensation then by pecuniary period. The amendments to the 1920 Act have been enacted to further this saline purpose by either streamlining the compensation process or enhancing the amount of compensation payable to the employee. Prior to Act 45/2009, by virtue of dipping provision in Explanation Note 2, Section 4, the monthly wage of an employee were kept at ₹4,000, even where an employee was able to prove the payment of a monthly wage in excess of ₹4,000. The legislature is in wisdom and keeping in mind a purpose of the 1923 Act as a social welfare legislation did not enhance the quantum in the living provision, but deleted it altogether. The amendment is in furtherance of the saline purpose which underlines the 1923 Act of providing to all employees compensation for accidents which occur in the course of and arising the employment. The objective of the amendment is to remove the dipping cap on the monthly income of an employee and extend them compensation on the basis of the actual monthly wage drawn by them. However, there is nothing to indicate that the legislature intend to benefit to extend to accident that took place prior to the coming into force of the amendment.
No, this is on different
Yes,
issue.
yes,
Issue is whether the amendment would be applicable to accidents which occurred prior to the amendment.
yes.
Yeah.
That is not a case
Yes, Lord.
before us.
After amendment, the Lordship amendment was come into force 3rd January 2020. Thereafter, the monthly was enhanced from 8,000 to rupees 15,000. It was come into force from 3rd January 2020. Prior to that, monthly wage was rupees 8,000. Since the accident took place 2019, so
No, it was from 8,000, it was increased to 15,000 again.
15,000.
Where is that notification?
Lordship will
Lordship,
find in the
it is
new act.
reflected in the judgment and it is categorically mentioned that 15,000 will not be applicable in the present case. Lordship, in the judgment.
Okay, I'll come to you.
Yes,
Have some patience.
Lordship, that is
But no, but that is the issue is where the claimant is able to prove that he's getting.
that was claimant was not able to prove that their income was rupees 12,000. Our High Court judgment. Lordship, kindly see our High Court judgment. In the same line, Lordship.
Which judgment?
Para number 5, Lordship. Being agreed by the impugn judgment and order dated 2/7/2014, passed by the labor officer cum commissioner and employee compensation Dorong Mongoldoy, in case number so and so, the appellate insurance at the outset has contended on the date of accident, that is 10/9/2009,
the statutory wage ceiling prescribed under the provision of section 4 of the Employee Compensation Act 1923 as per notification.
No, why the word ceiling is used?
But it is earlier. That act is earlier. In earlier act, it is categorically mentions. One explanation is there that 4,000, it's there. That's why in 2009, that explanation has been deleted. So that's why this my learned friend, whatever judgment referred in this judgment
No,
is
no,
saying.
you. Let him, I'm putting questions to you. You have some patience.
Not extreme, sorry.
Where is the word ceiling that it cannot be more than 800, 8,000?
They have to prove, Lordship. They have to prove the income, Lordship.
Yes, he has stated that.
Only statement is nothing, Lordship. Who the employer was examined, employer was not examined, Lordship.
So that is your submission,
Yeah.
that he is unable.
And regarding, as part of written statement of the employer, the salary was rupees 9,000 and 100 rupees was daily allowance. Daily allowance cannot be part and parcel of the wages, Lordship.
So 9,000 was admitted by the employer.
9,000 was admitted by the employer that salary was given 9,000 and another 100.
And if we take daily allowance into consideration, it comes into
No,
12.
Lordship. As part of Supreme Court rules, daily allowance cannot be considered as part and parcel of the wages, Lordship.
Why you have referred this judgment?
Lordship.
This,
Lordship. Kindly see, Lordship.
which para? What you want to emphasize from this?
Lordship.
Which para you are?
Lordship, only my submission is that, Lordship, in this case, the income of the deceased was not proved before the learned commissioner.
So that is a different case. Why are you relying that case in? How it will help you in this case?
Earlier it was 4,000. Subsequently, it was increased to 8,000. When the notification was at force, Lordship, before 2000, the notification was forced that the maximum salary of this is in absence of any proof of income. The
Yes.
monthly income of this should be considered as
Yes,
8,000
that is correct. In absence of any proof of income,
income. So
that
in this case,
notification.
there was no proof of income, Lordship.
But in this case, the employer himself has stated.
No, Lordship, he has not come to adduce evidence, Lordship. Reading is not evidence, Lordship. And regarding, Lordship, daily allowance, this is not a part of the parcel of the wages, Lordship. I have not brought that decision, Lordship. Lordship, may go to the 2008 5 SCC 428. Five SCC 428. The allowance given to meet the specific expenses are not part of the basic wages salary. It was held by the Supreme Court, Lordship. Our High Court division based judgment is also clear, Lordship, that daily allowance cannot be part and parcel of the wage.
Para?
So I have not got this decision, Lordship.
Which para?
But it may be recorded as part of Lordship. I have got the decision of
Lordship,
our High Court also. and,
Whatever my learned friend is referring, that judgment is specific allowances. If an employee is getting, a specific purpose.
Yes, anything else?
Lordship,
Anything else?
I shall place this in the judgment, Lordship, it may be recorded as part of Lordship. Day after tomorrow, it may be.
No, Lordship, everything is clear, Lordship. Whatever, Lordship, if code is. I will satisfy Lordship. There is a
No, I have
judgment.
to- I have to
Lordship,
place the judgment.
Lordship, there is a judgment of this our High Court. There's a month, daily wages is a part and parcel of this monthly wages. And if there is a Lordship, a specific allowances that may not be counted. And so far my understanding, Lordship, my learned friend is referring this specific.
Listed. For Lordship. Day after tomorrow listed, Lordship. I shall promise.
You should have stated this at the very beginning.
I have not got this judgment, Lordship.
মঙ্গলবার, বৃহস্পতিবার 26. On 26, day after tomorrow. As first hearing item. Not Mr. K.K. Bhatto, learned counsel for the appellant. This is item number
17.
also at Mr. I Hawk, learned counsel appearing for respondent number 1. The hearing remain inconclusive. Let this matter be listed on 26th of February as parted matter.
Yes.
The registry is directed to list this matter as first hearing item on that day.
Highly accept.
Item 18.
It's a matrimonial appeal, my lord. Against granting of divorce matters.
Take a date from the.
See, regarding item number 28, the matter has not been, for the last many times, the matter cannot not be reached, Lordship.
What can we do?
Our
prayer is that
Lordship,
this matter may be taken up on 5th. And if
Thursday.
possible, as a first matter in the hearing.
No,
Because the
no.
execution case is pending. Therefore, we are
On
requesting
5th, prayer is allowed.
all as a first side.
As a first item, Lordship.
No,
My
on
lord,
that day you make mention.
Right.
Item number?
Item number 20, my lord.
Your item number, Mr. Bhakhtiar?
28.
28 on 5th. Due to paucity of time, this matter could not be taken up. Let this matter be listed on 5th of March. Your item?
My lord, 20. March item number 20.
What is the prayer?
My lord, a date may be fixed, my lord. I am appellant, my lord. Appellant claimant, my lord. Suffering from financial hardship.
You are there.
Yes, Lordship.
Item number 20 at the date there. 26th March.
Most obliged, Lordship.
Item 22 maybe, my lord, 9th of March, my lord. Sorry, my lord.